So today my question is, if the law can move the word citizen, can it move who gets to speak? The First Amendment bars laws abridging speech, and for generations, courts have applied that protection to persons on U.S. soil, not just citizens. We just saw that principle tested. In September of 2025, a federal judge in Boston ruled that the admin unconstitutionally targeted lawfully present non-citizens for deportation because of their Gaza-related speech. The court called these ideological deportations and found them to be classic viewpoint discrimination. That decision is now being appealed, but for now, it reinforces a basic truth. Inside the U.S., speech protections apply to everyone who is lawfully here, even if they aren't a citizen. At the same time, there's another fight playing out, one that could redefine who counts as a citizen. In January, the admin issued an executive order that says some U.S.-born children would no longer be recognized as citizens, particularly if their parents weren't citizens or permanent residents. Lower courts blocked it, but in June, the Supreme Court ruled in Trump v. Casa that nationwide injunctions can't be used in cases like this, without deciding whether the order is constitutional. Plaintiffs then turned to class actions and state-led suits, which succeeded in blocking the order again. The admin has now asked the court to take up the full question. Now let's pause. Everything I've said so far is fact. Here's where we step into speculation. So what happens if the legal definition of citizen becomes uncertain? Could officials use that ambiguity to treat more people as non-citizens and then use their immigration status to chill their speech? On paper, that's not how it works. And the Constitution protects persons, not just citizens. And courts have ruled again and again that lawfully present non-citizens have First Amendment rights. But in practice, a person whose citizenship is suddenly challenged might face the initiation of removal or even short-term detention, depending on how the case is framed. If they're a student or work visa holder, their visa might get revoked. Even if they win in court later, the process can discourage speech, to put it mildly. Before we move on, Jonah R. sent in a dedication to help support this content and channel. His dedication reads, "For my grandfather, Eli, who taught me how to listen, how to plant things, and how to show up for people without needing to say much." Thank you, Jonah. That means a lot to me. And if you would like to offer a dedication in a future video, just head to the link on screen or in my bio. Okay, back to today's topic. There are guardrails. In Yick Wo, the court said equal protection covers all persons. In Bridges v. Wixon, it said that resident aliens have freedom of speech. And in the 2025 Boston ruling, the court again rejected viewpoint-based immigration enforcement. The Supreme Court has also ruled that the government can't punish people by taking their citizenship. In Afroyim, I think I'm saying that right, it said involuntary denationalization isn't allowed. In Trupp, it called denationalization cruel and unusual. The only exception left is fraud, and that bar is pretty high. And still, history warns us. In Dred Scott, the court erased citizenship and rights from Black Americans. During the Palmer raids, immigrant radicals were arrested and deported for their beliefs. And in World War II, even U.S. citizens of Japanese descent were imprisoned, based on ancestry, not law. So here's the question. If the definition of citizen becomes elastic, could the right to speak become elastic too?